Señoras y señores, me llamo Michał Lutek y soy el candidato al doctorado en el Instituto de Derecho Internacional Especial y Aeronáutico. Al principio, déjenme agradecer a los organizadores por preparar este evento y permitirme formar parte de él. Desearía poder visitar Sudamérica, pero pienso que esto sería posible en el futuro. Como pueden escuchar, no soy un nativo hispanohablante y por eso presentaré mi ponencia en inglés. Sin embargo, si tienen alguna pregunta, no duden en enviarme un correo electrónico, incluso en español, y responderé con placer a este correo. As you can see, the title of my today's presentation is Cape Town Convention and Space Protocol as a legal booster for space industry development, which in Spanish is la Convención de Ciudad del Cabo y el Protocolo Espacial como un refuerzo legal para el desarrollo de la industria espacial. This subject is particularly near and dear to my heart, as it is also a part of my doctoral dissertation, which I'm currently working on. What more, I believe it also corresponds well with the subject of the conference. Today's speech will be divided into 5 sections. First, I will provide you with a brief overview on the Cape Town Convention system. Then I will give you some insights into the space protocol, also from the private international space law perspective. Subsequently, I will indicate the major advantages of the Cape Town Convention and space protocol. The conclusion will be followed by an answer to the question, how can the Cape Town Convention and space protocol boost the development of space industry? So the full name of the Cape Town Convention is the Convention on International Interest in Mobile Equipment. It was concluded in Cape Town on 16th November 2001, as was the protocol on matters specific to aircraft equipment. An innovative feature of the Cape Town Convention is a dual approach mechanism, which is based on 2 fundamentals. One is the convention itself, which sets forth general rules for international interests. The other are the protocols, which in detail regulate aspects of international interest, specific for certain categories of objects, which include their idiosyncrasies. The objective of the Cape Town Convention is the protection of interest of the sellers, purchasers, and creditors, generally by creation of an international interest and registering it in the international registry. These 2 things, along with a wide and easily enforceable catalog of default remedies, gives organizations involved in space assets financing more confidence and lowers the finance cost, because as the debtors who have maintained their financial obligations are protected from the unwarranted seizure of the assets by creditors. As of 15 May 2020, which is today, there are 80 contracting states to the convention. Please note that this number only applies to the convention itself, not to the space protocol, which I'll explain later on. As you can see now on the slide, there are a number of Southern and Central American countries being the state party thereto. I focused on this region on purpose, but there are many more countries who agreed to bind themselves with Cape Town Convention. As I have already pointed out, the convention introduces a dual approach. Currently, there are 3 protocols to the convention: the Aircraft Protocol of 2001, the Rail Protocol of 2007, and Space Protocol of 2012. Presently, the UNIDROIT, which is under the auspices of which the Cape Town Convention and protocols were prepared, is working on the MIC protocol, which stands for Mining, Agriculture, and Constructions. But the protocol hasn't been adopted yet. Mm, Let us now focus on the space protocol. Space protocol could be perceived as a maybe as a wind of change in the international space law. The treaties constituting the Corpus Juris Specialis were adopted between 1973 and 1979. Thus, they do not exactly reflect the shift of the paradigm in space activities. The space activities were previously, as you know, dominated by state actors, and now the role of private entities is getting more and more attention. It is also considered, the Space Protocol, of course, it is also considered the first private international space law act. So we can witness such solutions already in aviation industry. There are some treaties having the same features. The internationality of space protocol is envisaged in the cross-border character of the transactions which are governed by Cape Town Convention. But as for the private aspect of the CTC, it applies to legal relations between legal and natural persons, not the public entities. So it's not a public international law act per se. It's more, as I already pointed out, it has more sort of a private features. The protocol has not entered in force yet. Simply because the requirement which is set forth in the Article 38 stipulates that the protocol enters into force between the states which have deposited instruments on the later of the first day of the month following the expiration of 3 months after the date of the deposit of the 10th instrument of ratification, acceptance, approval, or accession. Basically, the requirement of 10 documents hasn't been met yet, as there are only 4 signatories, which are Burkina Faso, Germany, Saudi Arabia, and Zimbabwe. Although the Cape Town Convention and Space Protocol are, without a shadow of a doubt, an innovative instrument of international lawmaking, Space Protocol is not widely accepted. There are some motives behind such reasoning. First of all, some space industry representatives do not see the need for such regulations. As to the remind, current regime for assets financing, space assets financing is sufficient. The low interest in the space sector, in the space protocol, might be also quite troublesome for the UNIDROIT, as they put a lot of effort and work in drafting process. Also, in the situation when the protocol is adopted only by a low number of states, this could be seen as a questionable success for us, for international community. Just to give you a perspective on this, the aircraft protocol, so the youngest one, has been adopted by 77 contracting states. So the difference is quite striking and visible to the naked eye. What should be mentioned here is also that nearly 10 years ago, on December 9th, 2011, almost 100 leading players in commercial space industry signed a petition which was supposed to urge the UNIDROIT to reconsider the adoption of the draft of space protocol. At that point, it was draft, not the protocol itself. But generally, this shows that the review and the amendment of the space protocol is needed and also noted by the industry. Having said about some drawbacks of the convention, let's move now to something more optimistic, namely the advantages of the Cape Town Convention system. What What I can see as a positive outcome of this convention is firstly the cost efficiency. Cape Town Convention main objective was to reduce risk for creditors and borrowing cost to debtors, which generally results in lowering of the whole transactional cost. This also promotes the granting of credit for the development of space activity. As a result, no additional mechanisms to secure the transactions are needed. Second thing is predictability. International interests recognized in many contracting states and the establishing of an international electronic registry system allows us to enhance the predictability with respect to the interests which are held by sellers or lessors of space assets. International interest is easily accessible via website. It also offers us quite friendly interface for users. I checked it personally. It's not very complicated to search the register and to find the interest we want to check. Third thing is the easy enforcing mechanisms. A convention offers a wide range of default remedies, also such including the particular features of space asset, which is a unique tailor-made solution for space companies. As you probably know, the general provisions governing the secure transactions do not reflect the idiosyncrasies of space assets, which are quite unique group of objects. Last but not the least, it also gives us flexibility. This is the feature guaranteed by dual approach mechanism. So the convention and the protocol, I think I discussed it briefly in the previous part. So now I'll just move to our main question, which is how can the Cape Town Convention and Space Protocol boost the development of space industry? As you can see, the Cape Town Convention role as a booster for space sector development is threefold. All the three aspects are strongly connected with each other. That is why I decided to depict them in a sort of a triangle. Cape Town Convention can help us by attracting space companies and funding to the Cape Town Convention state parties. It also enables us to help local companies with acquiring this funding for their space ventures, and for creditors to secure their situation. Slowly wrapping up my presentation as I'm coming to the end, I wanna give you some conclusions. First of all, Cape Town Convention in general shall be considered as an innovative and progressive legal act. I think that its partial success is or might be reflected in the aviation industry, where the number of contracting states the aircraft protocol is quite high, whereas the popularity of space protocol is not extremely high, to put it mildly. Space protocol could also be considered as a first private international space law act, what might be seen as a shift in the perception of space law, now being more focused on private actors. This also leads to the necessity of taking decisive steps to amend and review the space protocol, so that it could share the same success as its older brother, the aircraft protocol. Even though it was, I think, a theoretical analysis, I hope that it was clear that once the space protocol is enforced, it surely may be seen as a booster for space activity development for the contracting state. Thank you for your attention. If you have any questions or additional clarifications be needed, please feel free to contact me. You have my email address at the bottom of the slide, so I would be pleased to answer all your questions or comments if you have also any notes on this. I would be happy to discuss it with you on the email basis. Thank you very much. It was a pleasure being a part of this conference, and I'm really looking forward to taking part in it in the upcoming year, hopefully in a normal surrounding, not a virtual one. Thank you very much.